Good morning, everybody, and welcome to this edition of Macro Pro and Friends. We're excited because we are combining our forces with the EWC and some of their speakers or people that did apply but weren't able to participate as a speaker this year. So I'm joined by Deborah, hence my twin sister. Deborah, how are you today?
I am lovely, and you, darling sister?
I am fantastic. It is nice that we get to be together and get to do this. So tell our audience, for those who do not know about the EWC, what it is, when it is, and I understand you have a special treat for everybody.
We do. So the Executives and Workers Comp is a conference that we are having on April the 4th. That's going to take place in Anaheim, California. And it's from 8 o'clock in the morning to 5 in the afternoon. You get 5 CEUs. We feed you better than any other conference. That is what we are known for. We do great food. We have wonderful, amazing speakers. This is going to be like a little taste of what just coming ahead. And for those who would like to join us and have not registered already, we are offering a $100 discount from $450 to $399, and that is using the discount code EWC when you go online at www.ewcconference.com.
Okay, well, that was a mouthful, but I am so glad that you gave everybody the opportunity to join us at the conference and see what it is. Now, the conference is where and what day?
It's going to be in Anaheim. It is April the 4th, and it's from 8 to 5 o'clock. And then we have a wonderful happy hour that Sedgwick is sponsoring.
Oh, very nice. All right, well, let's get started with our program today. Today we have a program on Medicare, and it's going to be a fantastic one. So you get one California CEU for this, and you want to make sure that you check your email for that. You should receive it in 1 hour. I can help you retrieve that if you need, or whatever you need, for 30 days. So if you don't see it in your mailbox in 1 hour, make sure you reach out to me so we can do that. You do have to be logged on to the GoToWebinar platform in order to receive that. So there are handouts. Unfortunately, I was unable to get it attached to the control console. So if you'd like a copy of it, please put that in the question box and we will make sure you get it. Speaking of questions, my friend Debbie Wilson is going to be monitoring the questions and asking them of our experts. So if you have any questions, please put it inside. Hi, Felicia. It's good to see you too. So glad you're here. And then if you'd like to see this again, you can do so on the Macro Pro YouTube channel. So Debbie Wilson, why don't you come up and tell us what you're doing with this firm and how long you've been with them and what they're going to be talking about.
Hi, Diane. Thank you so much for having us today. Again, my name's Debbie Wilson. I'm the Vice President of Business Development for Allan Koba Compliance Solutions. We are a full-service Medicare compliance company providing, everything that is needed in MSP compliance, whether it's the past conditional payments or the present Section 111 reporting or the future of Medicare set-aside. And I've been with them for approximately 6 months, and I am so proud to be part of this organization. Ciara and Michelle and the rest of the team are experts in their field, and that's who you want to learn from when learning about Medicare secondary compliance.
Well, I've heard them speak in the past. I know they're going to be a treat today. So go ahead, and I'm going to turn it over to you and your team.
Great. Thank you, Diane. I would like to introduce to you today Michelle Allan. Michelle Allan is principal of Allan Koba, as well as Ciara Koba. She is also principal at Allan Koba. They have decades of experience in this space. And again, learning from industry experts is definitely where you want to be, especially with the new things coming up. Medicare dropping some bombs last year about what we're doing for auditing and, civil monetary penalties. I know it's a hot topic. So without further ado, I will introduce to you Ciara and Michelle. Take it away.
Thanks, Debbie. Today we're going to talk about preparing for a mock audit. And whenever we're talking about mock auditing, we're referring to the compliance area relative to Section 111 reporting. As you likely know, Medicare secondary payer compliance is comprised of 3 different aspects: Medicare set-asides, Medicare conditional payments, and Section 111 reporting. And the Section 111 reporting is really what ties it all together. This is the electronic data exchange of information between responsible reporting entities and CMS, the Centers for Medicare and Medicaid Services. The RREs are entities that have obligations to be making payments in liability, including self-insurance, workers' compensation insurance, and also no fault. So any entity that's got that responsibility can register as an RRE and do the electronic data exchange with Medicare. The purpose of providing this information to CMS is twofold. It's to allow the government to recover conditional payment amounts for anything that they might have made a payment for where the RRE is responsible for making the payment. And it's also to avoid making payments for medical care that there is an existing RRE responsible for making those payments. So this is the information about a Medicare beneficiary, including ICD-10 codes and other relevant information that gets sent over to the government so they can go forward with their avoidance and recovery plan. There's been a lot of talk, as Debbie had mentioned, about the rulemaking relative to Section 111 reporting civil monetary penalties. And this is a rule that goes all the way back to the statutory obligation to provide this information to CMS. And it's taken many, many years to unfold. And in October of 2023, CMS published the final rule, which gives a lot of good information. We're not going to go into all of the nuts and bolts of that today because the purpose of the webinar, of course, is to talk about how to make sure your program is compliant and how to conduct a mock audit. But it is important to know what the relative dates are. So in terms of when this is effective, the rule published indicated that it was 60 days after the date of publication, which is December 11th, 2023. The date of applicability is 1 year later, which is October 11th, 2024. So no civil monetary penalty will be imposed until at least 1 year, and that's 365 days, after the latter of the applicability date of this final rule or the coverage effective date for an ongoing responsibility for medical, or the settlement date, which is the total payment obligation to claimant date. So the big question everybody wants to know is how long do we have to get our programs together and to engage in mock audits and to figure out whether our program is performing optimally? Well, the earliest date that a civil monetary penalty can be levied is no earlier than October 11th, 2025, and then 365.
All right, so there's really, it's been a simplification that's happened with CMS since they have actually promulgated the final regulations for how they're going to penalize for civil monetary penalties. And Michelle and I were both attorneys. I was actually a nurse before I became an attorney, and we were trying to figure out and thinking through ways where we could simplify how to explain this to carriers so that they can help themselves get ready for civil monetary penalties and figure out how they can most effectively prepare their programs, prepare their teams, and stay compliant. So we're really going to focus on the simplest, most to the point way that you can make sure that you are ready for any CMS audit and for CMPs. A very common strategy when you're getting ready for a trial or you're getting ready for a big litigation is to do what we would refer to as a mock trial. It's one of the first things you learn when you're in law school, but it's insanely effective. I don't know if any of the people listening are the type of people that before public speaking go in front of a mirror and practice their whole speech before they give it. But believe it or not, all of that practice helps. I don't like to say practice makes perfect, but I like to say practice makes progress. So the more you practice doing this right, the more you take a look at what you're doing, and the less you are afraid of it, the better off you're going to be in the long run. So what we're going to do today is we're going to talk to you about the timeliness, and we're going to focus on timeliness and what that means. Then we're going to talk through how you can take a look at your program and assess your own risk by giving yourself a mock audit. So where you're going to start for timeliness is the TPOC date, like Michelle had said in the last slide, and the ORM assumption. So CMS isn't going to be looking at your ORM term dates and assessing timeliness based on that. They are only going to look at the timeliness of your reporting for the TPOC date and amount, which could be the date the payment obligation was established, either via settlement, judgment, award, or any other payment that is made to a beneficiary to either fully or partially release medicals. Indemnity-only settlements are not TPOCs. That's pretty well established, but questions come up about that every once in a while, so I did want to mention that. Now that's the easy one. TPOC date is easy. ORM assumption is not so easy. And the reason for this is you don't actually report an ORM assumption date. There's no field in the current Section 111 data elements that allows you to specify as a carrier the exact date that your legal, contractual, or otherwise obligation to pay for medicals arose. And your obligation to pay for medicals for different body parts for the same person, or different dates of injury for the same person that have all been consolidated into one claim, complicate things even further. We're going to try to simplify this, but the trigger for CMS is going to be using the definition of ORM, which is the determination by the RRE to assume an ongoing responsibility for medicals, or ORM, as I like to refer to it, or ARM, kind of sounds like ARM to me, which is when the RRE learns through normal due diligence that the beneficiary has received or is receiving medical treatment related to the illness or injury sustained. So it's an assumption of an ongoing responsibility, plus you've got to know that they're getting treatment, and you have to have some idea of what the actual injuries are. You have to have an injury to be able to report ongoing responsibility for medicals. So doesn't necessarily mean that you're paying for the treatment, but it does mean that you are exercising due diligence to figure out what they're treating for and what's been alleged and what happened. And that's not always the easiest thing to do, depending on the claim or the policy or the type of insurance, but these are the triggers. So that's what we have. That's what we have to focus on. And we've got to figure out how to get the answer to that. Next slide. Next slide, Debbie. Okay, so what can the RRE be penalized for in terms of the non-compliance? So the non-compliance, again, it's timeliness. So what is the timeliness? It's 1 year. So basically, you have 1 year to report your claims. That's it. 365 days from the date of occurrence. What is the date of occurrence? It's your TPOC date or your ORM assumption date. We're going to talk about a little bit more about what CMS is going to use for that ORM assumption date on the next slide. Next slide.
So what constitutes timeliness? As Ciara had said, this is what CMS is focused on whenever it's determining whether an RRE is non-compliant. Timeliness is determined by comparing the date a record is submitted and accepted against the date that CMS should have received the record. And the date CMS should have received a record is determined by the effective date of coverage, ORM assumption, or the date of the TPOC, or TPOC funding date if the funding of the TPOC is delayed, plus 1 year, and that's 365 days. This is what they're focusing on. Next slide, please. Another big question that the industry had prior to the final rule being published was who and how is this going to be audited by CMS? Or if it's going to be audited by CMS, or whether they were going to subcontract this to a recovery audit contractor or some other organization that might be hired on a contingency basis to go about it, and what types of volumes. People are very concerned about all of this, and it's all come to light recently. CMS is going to be conducting audits itself. Members of the CMS Medicare secondary payer team are going to be doing it on their own. They're not going to be engaging with a third party or any sort of a recovery audit contractor. They're going to randomly select records to quarterly audit. CMS will review each selected record to determine if it complies with the reporting requirements. So this is going to be an in-depth review by people who are familiar with Section 111 reporting and all of the various nuances therein. CMS is going to select 1,000 records for review on an annual basis. So this is 250 individual beneficiary records per quarter. And this is a pro rata split between group health plans and non-group health plans. So they're going to be looking at it in terms of how many group health plan reports they get versus non-group health plan, and it will be split on a percentage basis. So I believe that the metric that they've recently shared is that 60% of the records they receive are group health plan, and 40% as of right now are non-group health plan, but that's on a sliding scale and it can be adjusted. So you're looking at 1,000 records per year, 250 of those quarterly, and it will be divided based on which of the two entities is providing more Section 111 reporting. Next slide, please. I can't hear you, Ciara. I think we don't have sound.
Ciara, perhaps you can switch to either calling in or taking, using the computer's audio. Michelle, can you take the slide?
Yeah. So one of the things that many RREs are doing right now is conducting mock audits. And Ciara, whenever she has a moment, can explain some of the projects that we've worked on over the last several years. Companies have been doing this for quite some time, trying to get ahead of where the final rule might be. There had been a draft rule that was published, and several insurance companies and other RRE entities have been working to try and be compliant with it. But now that we know what the final rule says, we can be more specific about what we're looking for when we do conduct a mock audit.
Thanks for covering for me, Michelle. Debbie had told me that my other headset was breaking in and out, so I tried to switch it, and then I was gone forever. So lesson learned. I will never do that again. All right, so I'm on my phone audio now, so hopefully you guys can hear me clearly. And I didn't hear anything Michelle just said, so I'm going to pretend that that didn't happen, and I'm just going to start off on how to run a mock audit. All right, so where do we start with that? So the best place to start when you're doing a mock audit is the diagnostic review. So to do a diagnostic review, it really can be, how do I want to say this? It can be tailored to the type of business and the type of risks and known exposures that you already have. So for example, if you are a general liability carrier that doesn't have very much ongoing responsibility for medicals, you're going to focus on different things than a work comp carrier is going to focus on. But when you do that diagnostic review, you want it to be independent in terms of you want to take a randomized sample. So you don't want to have someone picking claims that could potentially be the person that would be responsible if those claims had been reported incorrectly. So you want to keep this as independent and objective and randomized as possible. But with that being said, definitely stick to claims that have Medicare issues. You don't want to audit a bunch of claims where you don't have beneficiaries, or you don't want to audit a bunch of claims where they were settled 5 years ago. And you know that they're not going to be subject to civil monetary penalties because the effective date of the rule is not until October of this year. So again, when you're looking at an audit just to focus on civil monetary penalties, you definitely have a slightly different focus than you would if you were auditing for conditional payment issues or Medicare set-aside issues. Additionally, you want to look at your policies and your procedures. What have you set up as a company to focus on Section 111 reporting? Where are these policy and procedure manuals housed? Who has access to them? Who understands them? How often are you doing learning and training and refreshing of these policies and procedures? If we know anything about CMS, we know that they change their methods and their policies and their regulations pretty frequently. So, make sure that you have somebody, either a vendor partner that you're working with or someone internal inside of your own business that is keeping up to date on this, that is signing up for CMS alerts, that is aware of where the policies are, that has been selected as your go-to person if anyone on your team has a question about any of this. Because the other thing to remember is Section 111 reporting is a huge risk for carriers, and there's a lot of possible liability here. But it also is something that doesn't impact most claims professionals every day, or even a majority of their files. On average, only about 20% of all cases, and this is a very big average, that a carrier will see have Medicare beneficiaries. Now, that number could be much higher in workers' compensation in certain industries where you have maybe an aging workforce or tend to see some catastrophic injuries where people end up on Social Security disability and go right to Medicare in 24 months. But on average, most claims professionals, insurance adjusters, executives, they're not seeing Medicare secondary payer on a daily basis, which is why vendor partners are important. And they're an important piece to any program. And this kind of led us to mock audits. Now, we've been doing these for 10 years. We wanted to call it this now because we thought it would help people to really understand what they might face when CMS decides to audit them. So once you've done your diagnostic review, once you have taken a look at all your policies and procedures and identified your known risks, the next step is claim remediation. So what did you identify? What did you find? And how are you going to fix it? What questions are you going to ask? And the questions can be just as important as the answers. So knowing to ask the right questions is going to get you to the right spot. So which teams need more training? Which adjusters need more support? Which types of claims do we seem to be making mistakes on? Why is that happening? Is there a certain fact pattern that keeps arising that we are missing the mark on? Are there certain jurisdictions where we tend to report later than others? Are there fact patterns or factual scenarios that keep arising that are causing us to be unsuccessful with this program? So the claim remediation and the questions that you're asking yourself as a business and as leaders in your company are just as important as anything else that you're doing. The next question becomes, are you going to do this as an internal or an external audit? And our recommendation would be to do both. You should always be looking at what you're doing and have some sort of a internal quality assurance program. But what we have found is that employing external audit partners will definitely hold your existing team more accountable than not. So you always want to make sure that you have, some sort of a third party affiliation when you're thinking about how to do this auditing, because when CMS comes in, they're not going to look at this from the same lens that you might be looking at it internally. And that's what's helpful. And that's why it's helpful to have a vendor partner help you with this. And then what do you do with the results? I mean, the first thing you want to do is identify the biggest problems that you have with the largest risk associated with it. So which claims are reported the latest? Which ones are taking the longest to report? Which ones aren't we really struggling to even get the information on to report? Which teams are struggling with understanding what data needs to be reported? Because the other factor that's going to play into this is if something is reported late, but also is incorrect, will that exacerbate the problem even further in terms of what was actually reported? So for example, say you reported something late, but you also didn't give CMS any of the correct information. Now you have other issues. You have contingent liabilities and conditional payments. So I think what you do with the results is going to not only help you fix your Section 111 reporting timeliness, it's also going to help you fix your program overall as a Medicare secondary payer compliant business. Next slide. Okay, so Michelle and I are going to run through an audit with you, and we're going to keep it super simple. So we have a very easy fact pattern, okay? ORM, or ARM, we got an ARM on January 1st of 2027. So we assumed responsibility for medicals. We didn't report that ongoing responsibility for medicals until March 1st of 2028. Now, as we walk through the rest of this, I'm going to throw in some different scenarios in terms of why that happened. But we did not report the ongoing responsibility until March 1st of 2028. So here are the questions that you need to ask. 1, how will CMS determine when ORM was assumed on this one? 2, what period of time will be used to determine compliance? 3, will CMS always use the date of incident as the ORM assumption date for purposes of timeliness? 4, how many days can CMPs be imposed for based on this time frame? And what is your total possible CMP for this example? Next slide. Okay, so the answer to question number 1 is CMS will look at their data that they have available to them through Section 111 reporting, but they also will look at their other sources. So they're going to take a look at group health plan reporting. If you are doing conditional payments and you're sending in settlement documents or claim information in that manner, they're going to look at that. If you've tried cases to verdict and there is a public record of settlements and payments being made to Medicare beneficiaries, they have access to a lot of different ways where they can get this information. But let's just pretend for purposes of our really simple example that you did the Section 111 reporting late in March of 2028. So what period of time could you then, as an RRE, be subject to CMPs? Well, you became non-compliant on January 2nd of 2028. And the reason for that is journeying back, your ORM assumption was January 1st of 2027. You get 365 days to report that. So on January 2nd, you are on your 366th, that's a tongue twister, day of the time frame in which you had to report. So you are on day 1 of being non-compliant. Then you don't report until March 1st of 2028. So you have a total of 59 days of possible non-compliance. So the next question becomes, is CMS going to use the date of injury as the ORM assumption date for purposes of timeliness? Yes, they are. So I'm going to throw like another wrench in this. You assumed ORM on January 1st of 2027, okay? But maybe your date of injury was a year prior. CMS could look at this and put you in a different category for penalties based on that date of injury. Now, you may not have had any ongoing responsibility for medicals for that first full year And it could be for many reasons. It could be for the fact, it could be a state law reason. You could have a state law argument. You could have disputed compensability and had a time frame for which you didn't have compensability. There could be a whole host of reasons as to why the actual ORM assumption date or your legal contractual date of responsibility is different than the date of injury. You could have multiple dates of injury being reported under the same claim input file because you consolidated claims for the same beneficiary under one claim, and your claim system only reports that one claim. So all of these examples that I'm giving and hypotheticals that I'm talking through, what they are all going to amount to are mitigating evidence, okay? So, but let's keep it simple, and let's say that your date of ORM assumption is the date of injury, and let's just pretend our date of injury is January 1st of 2027, such that you had 59 days of non-compliance. So what is your total possible CMP for being 59 days late? $21,063, excuse me. And the reason for that is you fall into a category, and we're going to move to the next slides here, and we're going to go through the categories for penalties. You fall into a category where you have $250 per day penalty, but because of inflation, it's actually $357 per day per penalty. Then I'm going to pass this over to Michelle so she can talk you through the different categories of noncompliance.
Yes, and this is a piece of legislation called the SMART Act that was passed as a piece of reform legislation that provided for some sort of scaling or grading of offenses, and that's what we see here. This is what was set forth in the final rule, so that you have different monetary dollar values associated with various timeframes of compliance. So these are not necessarily a true cap. Instead, it's again, it's a grading and a scaling of offenses. And one of the questions that the industry also has is whether there's any real limit to the amount of civil monetary penalties leveled on an individual RRE. And we've asked Medicare a few different times about this as well. If they go through an audit and they start to find offenses, would they continue to further audit the records of any given RRE? The answer to that is no. They say that they're going to keep it randomized and that they're going to stay with the single record that they have. But I suppose if any given RRE has just terrible luck, they can be found several times in an audit, and if they aren't compliant, I suppose that there isn't truly a limit to any amount of CMPs levied on an individual RRE. But we did speak to what the numbers are in terms of how frequently and how voluminously they intend to audit, and I think you'd have to have just the worst luck ever to be hit by lightning multiple times, but it is possible. So when we're looking at the grading and scaling, Medicare has set forth $250 per calendar day of noncompliance, where the record was reported 1 year or more, but less than 2 years after the required reporting date. And then for a more lengthy time period, you've got $500 per calendar day of noncompliance, where the record was reported 2 years or more, but less than 3 years after the required reporting date. And then you've got the full $1,000 here, which is per calendar day of noncompliance, where the record was reported 3 years or more after the required reporting date. Now, this is not based on the inflationary adjustments, which are referenced at 45 CFR Part 102. Next slide, please. Let's talk about that. Inflation is serious business, and there are regulatory provisions for not only this piece of legislation, but others that fall into the same sort of regulatory schemes here, where adjustments are made on an annual basis. And if you're looking at what the max penalties are and what those inflationary adjustments look like, rather than $1,000 per day, you're looking at $1,428 per day for an annual penalty total of $521,220. It's more than $500,000, and that could be on a single claim. $250 per day penalty is $357, which is what we were utilizing for the previous slides. And then $500 per day is now $714 per day. Now this is for 2023. It's going to go up every year. Next slide.
Now CMS has explained, and they have updated the federal regulations to include this tiered approach, and that's what we have on the screen here. This is the section of the regulation where they have the tiered approach, and they do have the max penalty down below. Now, one of the big questions originally, because of the way things were worded, was, is this really a max, or is there really any cap on penalties? And the answer is yes, there is. It's just that the cap on the penalty is not $365,000. It is $365,000 as adjusted annually for inflation, which is the section of the federal regs that Michelle just showed you. So right now, if you were audited and you had not reported for the length of time, so 3 years or more after when you should have reported, your capped max penalty would be $521,220. Now, this rule goes into place on October 11th of 2024. So the first time you could be penalized for any late reporting would be October of 2025. Then go out another 3 years from October 2025, or I should say 2 more years from October of 2025, and you would be hitting that max penalty amount. And who knows what the inflation will be at that point. You've got to remember that this law has been on the books for over a decade. So it was passed in 2007. It officially started to be part of our universe in 2009, 2010. So inflation has grown quite a bit. It's grown almost 43% since that period of time, because the law has been on the books even though it hasn't been applied. Next slide. So we're going to do another example, and this one's a little bit worse. So if your TPAC date is January 1st of 2025, okay, and pretend you're auditing your own claim, you have 365 days to report it, but you don't report it until October 15th of 2026. You needed to report it by January 2nd of 2026. How much time does CMS have to audit you for that late reporting and actually levy a CMP? So like Michelle said, get struck by lightning. How long does CMS have to strike you as an RRE by lightning? Strike you down, make a diamond. They have until January, they have 5 years, from January 2nd of 2026, because that is your first day of non-compliance. So another really good thing that came out of the CMP rulemaking was a very clear statute of limitations. Now, say they get to you before this date, you will be considered non-compliant for the period of January 2nd through October 15th, which is 286 days, assuming you can't present any mitigating efforts or be subject to any of the safe harbors, which Michelle is going to talk to you about in the next slide. You would be subject to $102,102 worth of penalties. So 102. It's a lot of money. And that's based on the current inflationary rates, not what they will be in 2026 or beyond. Next slide. Are you all feeling like you're experts at mock auditing yourself now?
That pretty good?
Yeah.
Well, there's a couple slides here that should make you feel pretty good. These are the silver lining slides here. What's that?
Save the best for last.
The best for last, yes. So if you're feeling uncomfortable, this might help you feel more comfortable.
This is your slide.
And really, whenever you're getting into a mock audit, it's meant to make you feel more comfortable about your program. It's meant for you to take a look under the hood and see what's going on, because as we've said, you've got plenty of time to make corrections and to identify where there might be needs for troubleshooting. And pursuant again to the SMART Act, Medicare set forth safe harbors, which was something else that the industry had asked for, so that there are different reasons why an RRE might have reported things the way that they reported that would protect them from any sort of civil monetary penalty. One of them would be time delays caused by CMS or its contractors in the reporting process. So that is pretty straightforward. RRE compliance with any reporting thresholds or any other reporting exclusions. So if there's other rules in place, such as the workers' comp exclusion for ORM, any pre-80 December 5th, 1980 exposure cases, or if there's any thresholds that are set forth that would preclude reporting, those are going to be taken into consideration as well. Also, untimely reporting due to lack of cooperation by the beneficiary. And this was something that many liability carriers have pointed out as being problematic for them in trying to capture information that's relevant to Section 111 reporting. The RRE must make and retain records of its good faith effort to obtain the information for 5 years. So that's something that RREs need to hold on to and document. The RRE must request the query information at least 3 times, once in writing, including email, once more by mail, and once more by phone or other means of contact. So that's going to be really helpful in documenting your file that you've at least attempted to obtain this information. And CMS recognizes that some beneficiaries might not want to share this information. They might be adamant against it. And Medicare isn't trying to put RREs in a position to belabor this or harass beneficiaries into finding this information out. They just want to see that attempts have been made, and of course, if a beneficiary is adamant about not providing it, they acknowledge that it's important to protect beneficiaries' identifying information, and they're allowing to show this as a safe harbor. And then also, the incident of noncompliance associated with a specific reporting policy or procedural change by CMS that has been effective for less than 6 months following the implementation of that policy or procedural change, or for 12 months, should CMS be unable to provide a minimum of 6 months notice prior to implementing such changes. So they're acknowledging that RREs need to have a little bit of time to get repositioned if there are going to be changes that are set forth, and they're trying to identify reasonable amounts of time therein. Next slide. And then mitigating factors. During Medicare's auditing process, if they are providing any sort of a pre-notification to an RRE that they might be considering a non-compliance penalty, there's an opportunity for the RREs to provide mitigating factors for why the report might not have been filed timely. Per the final rule, any mitigating factors or circumstances are welcomed, and a dialogue is encouraged to find solutions that are short of imposing a CMP. CMS believes it is in the best interest of all RREs to leave the informal notice process open to any reasonable submission of mitigating factors so that they are free to entertain all such documentation without strict limits. And that's something that we've asked them about a few times, and they've kept it very clear that they don't want to put any limits out there on what might be considered a mitigating factor, which is very, very good for the RRE primary payer community. That means that if there's any possibilities to try and explain why something was done the way that it was done or not done the way that it was done, Medicare's ears are open and they're willing to listen throughout this process. And this is something that can also be brought up during a mock audit. If it is identified that there are areas of non-compliance, perhaps a third-party vendor who is familiar with Section 111 and able to help with this process can help identify mitigating evidence and have it prepared and to include it. Information and documents that lend to mitigate non-compliance or explain technical errors, common mitigating factors, and document retention policies. This is all stuff that can come up during a mock audit. Next slide, please. This is more very positive information. There's a 5-year statute of limitations, and Ciara was alluding to that in one of the examples that she had mentioned. And this comes to us by 28 U.S.C. 2462, in which CMS may only impose a civil monetary penalty within 5 years from the date when the non-compliance occurred. Ciara, do you want to run through that example there?
Yeah, I'm sorry, I was typing answers to questions because we have a lot. We're gonna like run up against time, so I'm like, I'm gonna try to answer as many of your questions as I can in the chat. Yeah, so this is my favorite part. I love the 5-year statute of limitations. I love that it's clear, and I love that it isn't necessarily from the date of notice. Which would then just mean that there is a statute of limitations that goes on forever and ever and ever and ever and ever. So CMS has to use this by law, statute of limitations, to impose it, they'll apply it as long as it is 5 years from the date of when the non-compliance occurred. So realistically, say you were non-compliant and you never did your reporting, but there were other communications that went to the government such that they should have known or could have discovered that you were not compliant with Section 111 reporting, then you could apply this 5-year statute of limitations. But the important thing here is to know that CMS is going to be looking and is going to be auditing other types of data and other types of records to make sure that people aren't just not doing this reporting. So some examples here. If your TPOC date is January 1st of 2025, you as an RRE have 1 year from the TPOC date to report. I mean, if you leave this webinar and don't know that, I just, I don't know what to say. 365 days, 1 year you have. RREs will report on, the RRE then reports on October 15th of 2026, so they're late. CMS will have 5 years from January 2nd of 2026 to impose a CMP. So it's the date of non-compliance. It's not the date you report. So you gave them notice on October 15th of 2026, but your date of non-compliance occurred on January 2nd. So again, that's, definitely something that is beneficial to the RRE and does force Medicare to make efforts to try to get ahead of non-compliance outside of just the data that the RRE is sending to them. Also, if CMPs are imposed, the RRE will be considered non-compliant from that period of January 2nd to 2026 to October 15th, 2026. Same example as we did last time, $102,102 for penalty. Next slide. All right, and finally, last but not least, you can appeal their decisions, okay? So I know this is very concerning, but you can appeal the CMPs. So the way that this process is going to work is CMS is going to provide a pre-notice to the RRE. So what's really important here is if you are an RRE or you are a TPA for an RRE, make sure that the contact information in your profile report, in your 10 reference files when you're doing your reporting are correct. And that notice is not going to go to the wrong place. I'm hoping that we can come up with an electronic notice process, but you're going to get a pre-notice. It's probably going to go in the mailbox into like a snail mail, actual mail. And you will have 30 days to respond to the pre-notice and present mitigating evidence that Michelle just went over. for CMS to review prior to the imposition of a CMP. 30 days isn't a lot. So again, back to the policies and the procedures and acting on this and training your team so that they know if they get a pre-notice, they know what it even is. If you're a TPA, training your clients so if they start getting pre-notices, they don't ignore them. Because at that point, if you don't present anything, you are going to receive written notice of the CMP, and they're going to make a demand. From there, you have a regulatory appeals process. You can request a hearing with an administrative law judge. If you lose there, you can appeal the administrative law judge's opinion to the Departmental Appeals Board. You only have 30 days to do that. And from there, you only have 60 days to appeal that. But at that point, you're going to federal court. So you would need to petition for judicial review. So avoid it and do this right and start doing your mock audits. And I think that's it for us. We have lots of questions. So do we want to open it up now, Debbie, for questions?
Yes, we should do that. Absolutely. Thank you so much for this wonderful information. Experts in the field for sure. Let's see what we have here for questions. Trying to open it up here. I am not seeing them. The screen is so tiny down here, Ciara.
Okay, I can read one. I've answered a lot of them. Let me ask this though. Can you all see, and maybe someone else may see for this, but hopefully you can all see the ones answered because I've been saying them to all. If not, we can get a copy of this and send it out to everybody so you can see the answers. But the next one that I see in this list is, does this impact companies that electronically report to CMS? Yes, it does. Actually, that's the only way to report to CMS is electronically. So it will impact every Section 111 responsible reporting entity. Next question, would it be normal process to update your files and Medicare screens prior to an injured worker becoming a beneficiary? So if we update an ORM term date and a year or so later the applicant becomes a beneficiary, then when we electronically report, there shouldn't be anything we need to do, correct? So under this scenario, actually, if you have an ORM term date and you don't have an ongoing responsibility for medical and you don't have a TPAC to report when that beneficiary becomes a beneficiary a year later, that's actually not reportable. So you don't have to do anything in that case. Okay, next question. I understand when we have to report to be in compliance. However, it's still a little confusing. I appreciate your training. Oh, sorry, I thought this was a question. Thank you, Carla. Once I get the material, I can go back over it. If there are any questions, we can reach out. Yes, you can. Sorry. You can reach out. Of course, of course.
Tara, how about do the TPA one? This one says, if your TPA is doing your reporting, but you are the RRE, is this a safe harbor? Could you go over your answer?
Absolutely. So unfortunately, if you're, and a lot of people I think are under this assumption, take a look at your master service agreement with your TPAs. It will not be a safe harbor from CMS, but your TPAs themselves may have assumed liability for any reporting that was done incorrect. Now, given the amount of these penalties, you also need to make sure you're checking your limitation of liability provisions as well, because we all know it's over $500,000 error on one claim for doing late reporting, potentially in the worst case. And there's no cap on the number of records that you can be audited on in a given year. Like Michelle said, it would be extremely unlikely, but not impossible for an RRE to be audited on more than one in a given year. But it's possible, in which case, I mean, penalties can exceed $1 million. So again, a TPA not doing the reporting correctly does not act as a safe harbor for the responsible reporting entity. You would still be responsible for any civil monetary penalties associated with the late reporting.
The other question I think people would be interested in hearing is, these civil monetary penalties only apply to work comp reporting, not liability, correct?
Yeah, Michelle, did you want to take that one?
I'm sorry, could you repeat that one? I was trying to see if it was in the queue and I didn't see it.
Oh, no,
Sure.
I can take it. I already answered it. Yes, it applies to all lines of insurance for non-group health plans. So it applies to general liability, self-insurance, no-fault insurance, and workers' compensation.
If anything else came in.
Debbie, was there another question you were going to ask?
No, I think we're good on that. I know we're running up to time, so I look forward to seeing everybody at the EWC event. Please stop by our booth, and Michelle and Ciara are available for questions anytime or help with your Section 111 reporting. Please reach out to us, and we're happy to help you. And Diane, I'll pass it off to you.
Well, ladies, I would like to thank you very much for an outstanding webinar as always. I do have some reminders for our attendees today. First of all, Macro Pro has another webinar tomorrow. It's going to be Goodbye to Audit Agonies. It's going to be strategies for seamless goodbyes to compliance challenges with the WCAB and OSIP audits. So make sure you register for that. And then MacroPro also has some other in-person events that we're going to be doing. And so we have one in Roseville on April 25th. So if you're in the greater Sacramento area, be sure to check out our website for that. We have another one in the Bay Area, May 1st, and then one in Ontario. So all of those are listed on the MacroPro website. And since we were talking about Medicare, I do want to remind everybody that MacroPro can do your verifications for Medicare. So if you need to have that done, be sure to call on us. We're always here to help you in as many ways as possible. And then lastly, let's not forget about the great $100 discount for those of you who handle claims and would like to attend the EWC. When you go to ewcconference.com, you can put in that promo code EWC and you will get the discount. Again, that's only for those people who handle claims, not for any service providers. All right, until tomorrow, I will see you later. Thank you, ladies, very much for another outstanding job. Bye-bye now.
So much.
Thank you.